First is United States v. Rivera-Valdes out of the Ninth Circuit. En banc Ninth Circuit, but counts as an October case. And this is a big deal in the Ninth Circuit and elsewhere, even though it's happening in the illegal reentry context, 1326 prosecution. It's about collaterally attack a 1326 illegal reentry prosecution. You can attack that by collaterally attacking the underlying removal order that supports it. So it really is about the legality of the removal order at issue. So it's very relevant to removal proceedings, because this removal proceeding, or in this case, deportation proceeding, because it was before 1997, violated his due process, Mr. Rivera-Valdes. The reason why is exceptionally important to immigration. He was ordered removed in absentia because he didn't show up to his hearing. He was ordered deported in the early to mid 1990s. That was with the issuance of an order to show cause before they were changed to notices to appear. But I do believe that this holding should apply to notices to appear as well. Although orders to show cause, I want to say, had to be sent by registered mail or something. But other than that, this should apply. Former INS, before they became ICE, they messed up. He gave them his correct address when he entered, but they forgot to use the word avenue in what they gave. And so the mailings bounced back. The notice of hearing didn't have the date, time, and place of his first hearing. And that just goes to show that's why initiating documents are supposed to have the first hearing, so they know right then and there when they have to appear. But in any event, it didn't have that. So then the court sends the notice of hearing. That bounces back. They've got the wrong address. They didn't include avenue. And they actually try to send him the order to show cause again as well. That bounces back. So he doesn't appear, gets ordered deported, gets physically deported because of that, and then comes back in unlawfully, gets prosecuted. And the en banc full Ninth Circuit had some very interesting things to say about why that conviction cannot stand. I think they have to dismiss this indictment. Quote, when the government learns that its notice efforts have not succeeded, that knowledge triggers an obligation on the government's part to take additional reasonable steps to effect notice if it is practicable to do, end quote. That's a huge deal for in absentia cases. All these cases, the FOIA will show all the time that actually notice bounced back. It was not actually received by the non-citizen. Now, there's a lot of case law that says you can't evade the mail and you can't just move without informing the government. But even that is butting up against this rule from the Ninth Circuit en banc court, where it's saying that it is a due process violation for the government not to try to do something else when it learns that notice wasn't received. If there's not evidence in the record that the government did something else once the notice of hearing came back, it seems to me the Ninth Circuit is saying there might be a due process violation. Quote, process which is a mere gesture is not due process. The Ninth Circuit en banc even suggests things that the government could do. They could go back into the A file and make sure that there's no other address in the A file from the past to send notice to. That seems like something you could make a case out of through a FOIA. Any other address and the government didn't then try to send it? Due process violation. Reopening your in absentia removal order. Another alternative for the maybe sending the notice of hearing by first class mail. Government didn't do that in your in absentia case? Reopening. Motion, at least, due process violation. And the Ninth Circuit is very clear that its examples are just that, examples. You can come up with lots of practicable things that the government can do when the record shows that notice wasn't received as the basis for your in absentia motion to reopen in the Ninth Circuit. United States v. Rivera-Valdes.